Position 6, 25A01524, Nicholas Greco versus J. Cinnamon, MD.
Your Honor, I'm sorry, I misspoke earlier. We do want takedown. I'm understanding that defense is not going to share in that, but that's fine.
Okay.
Thank you.
And that is attorney for the plaintiff, correct?
Yes.
All right. Go ahead.
All right.
Uh, Go ahead.
Sure. Your Honor, thank you for hearing us on this issue today. This case is a med mal case, but we're not here to talk about the merits. This is a procedural issue that should be rather straightforward. The court entered a scheduling order in this case on May 15th, and the parties were able to pretty easily agree to each of the deadlines in that order and work together well on that. But there was one deadline not included in the order, which plaintiffs proposed that defendants would not agree to, and that's what we're here to talk about. Plaintiffs have asked that defendants be required to provide notice of their intent to apportion fault to a non-party at the same time that they identify their experts in discovery, which their deadline for that is April 1st as of right now. So what plaintiffs are asking is that at the same time that they say who their experts are, they say, we intend to allocate fault to X, Y, and Z. The statute applicable to intent to apportion fault says that the defendants have at least, they have to notify plaintiffs of their intent at least 120 days prior to trial. So the key points that I want to make here are that one, the statute we're talking about imposes a floor, not a ceiling, regarding when they must disclose whether they intend to apportion fault and to whom. Number two, what we're asking the court to do is well within the court's discretion. The court has broad discretion to make decisions about discovery and scheduling. And three, requiring the defendants to disclose their intention to apportion fault would only serve to promote efficiency and fairness in this case. So we're traveling under OCGA 51-12-33. And under that statute, a defendant has to give notice of their intention to apportion fault to a non-party, quote, not later than 120 days prior to the date of trial. In their brief, the defendants argue that the statute, quote, mandates strict compliance to the 120-day deadline. That's really not an accurate characterization of what the statute is doing. Strict compliance would mean that the defendants must give at least 120 days notice, not that they have an absolute right to wait until that point. The statute sets an outer limit or a maximum window, not a guaranteed grace period for the defendants. And if the legislature wanted to forbid earlier deadlines, it could have said a defendant shall not be required to disclose prior to 120 days prior to trial, but it didn't. Um, the reason that this is important is that if defendants decide to apportion fault to a third party, that's an affirmative defense that they have the burden of proving at trial. That's why they have to, under the statute, file a pleading explaining who they're apportioning fault to and the basis for that claim. Realistically, we have one opportunity to explore defendants' experts' opinions on their defenses, including an affirmative defense like allocating fault or apportioning fault to a non-party, and to prepare our experts to rebut these defenses. So if we spend months scheduling defense expert depositions, we go to the depositions, we're not aware that they intend to allocate fault, and we spend time and money deposing their experts and then months later find out, oh, we intend to.
I'm muted, sorry. Ms. Reimer, isn't it possible for you to ask at the deposition, uh, each time that you're deposing an expert, is there an intention to allocate fault to somebody else?
Yeah, that's an argument that the defendants make, but I would say that that's not really giving the plaintiffs the fair baseline that they need, that the statute really is designed to give them, because you really, it's kind of like a shot in the dark at a deposition. If you're like, are you blaming anyone else? The defendants may not have prepared their experts at that point if they're not even required to say that they intend to allocate fault to someone else. Um, so that's just, it's not
But
really.
wouldn't that be the time for them to, for you and for them to also explore whether fault should be allocated elsewhere?
It would be the time for us to explore it, yes, but we would need
But
to,
for them as well.
well, for their experts to give testimony on it, yes, and that's the point, is that we want to do it in one fell swoop. We don't want to depose their experts and then find something out later and then have to redepose their experts. I don't know if you have any experience scheduling expert depositions in a medical malpractice case, but it's
I do.
yes, it's next to impossible. It takes a long time. And if we get to a point where we're 120 days before trial, which in the context of a medical malpractice case is not that much time, and we find out that they intend to allocate fault to some other party, and then we have to rush to try to schedule a redeposition of an expert because we didn't ask them about that person or they didn't mention it, that's just going to put us in a really bad spot. And the defendants have not really articulated any prejudice to them for having to essentially state what their case is whenever they um, identify their experts. And that's all we're asking for, so that there's an even playing ground when it comes to discovery. Um, and in contrast, again, there would be a huge disadvantage to the plaintiffs because it would really throw us into a tailspin of trying to figure this out. And I just want to underline again, this is not something that is out of the realm of what the court can do. The court has very broad discretion, as you know, to handle discovery. It's not all that different from the court imposing an expert deadline to begin with. The statute is silent on when exactly there's no outer maximum deadline even for defendants to identify experts. But courts often, and the court did in this case, say that they had to do it by a certain date. And there's a reason for that. And it shares the same logic as what we're asking for here. So whatever time I have left, I'll reserve for rebuttal. Thank you.
Thank you. Let me hear from the defense.
Yes, may it please the court. Judge, you sort of hit the nail on the head. Um, I, this motion, in my opinion, is completely unnecessary. The plaintiff can seek this information during discovery. They can ask interrogatories. The expert disclosures under Georgia law, while aren't as stringent as in federal court, we do have to say generally what the opinions of the experts are going to be. And so if the experts have opinions about some other provider, then the time to disclose that would be during discovery and then during their depositions. And so, and if there are potential new opinions, then that is an additional deposition, but any delayed disclosure or additional disclosure that's delayed would be subject to Lee versus Smith analysis. So the court certainly has discretion to manage and control discovery, and the parties in this case have agreed on a particular scheduling order with expert disclosures laid out. Unfortunately, the court has no discretion to alter the deadline under OCGA 51-1233. The court can't limit a party's ability to actually assert non-parties to be considered for apportionment under this statute. It doesn't have discretion to alter the deadline because the Court of Appeals has held that the plain and unambiguous meaning of the statute mandates strict compliance. And that is seen in the Monotronics versus Beasley case. And I don't have the site, but it's a 2013 Court of Appeals case that discussed this exact issue. And so in that case, the defendants had filed a notice of non-party fault 120 days or 4 months prior to the trial. There was no trial set. And then the trial court set the trial for sooner than 120 days. And it held that, there was nothing it could do. It couldn't alter the deadline set forth under the statute. And so the defendants there were out of luck as far as being able to apportion fault to non-parties. Because the apportionment statute is a derogation of common law, it is limited to the strict compliance with its plain and unambiguous meaning. And so unfortunately, I don't think the court has any discretion in this case to alter the deadlines under this specific statute. The court, of course, has discretion to control discovery. And in this case, the court has done so by signing a scheduling order where it lays out the deadline to disclose defense experts and the deadline for depositions. And the plaintiff certainly can ask in written discovery if the parties intend to put the blame on anyone else. And I feel certain they've done that in this case already. So in short, there's just no reason for a special deadline at this point, except to artificially eliminate apportionment under 51-12-33 because it's potentially inconvenient to the plaintiffs. And I'm afraid that any such order would violate Monotronics versus Beasley and Lee versus Smith because it would exclude the defendant's statutory right based solely on non-compliance with the scheduling order that differs from the governing statute. So I just don't think this motion accomplishes anything useful. I think this information will bear out in discovery in a fair time for all parties.
All right, Ms. Reimer, you have 60 seconds.
Okay. As far as discovery, again, we can't ask meaningful questions about non-party fault unless we know who defendants intend to blame. And if they're not required to provide that information, they can withhold it. And as far as the statute itself and strict compliance, I would just say that what defendants are arguing does not comply with what the statute says. It's not a deadline in the sense that they're arguing. It is an outer limit. And the court does have discretion to move that outer limit, just as it does in many other contexts. So with that, I thank you for your time.
I think that OCGA 51-12-33 D1 provides sufficient time for the disclosure of whether non-parties will be named, and I think that you have sufficient discovery vehicles to obtain that information ahead of time. So I'm going to deny the motion. If y'all can submit a proposed order to me, please, by next Tuesday, that would be great.
Thank you, Your
Okay?
Honor.
Thank
May we
you.
be excused?
You may. Thank you.
Thank you.